It has recently been considered whether the inclusion of a hyperlink in an online publication with accompanying words such as "read the full story" amounts to the publication of that linked article by the linking author, an issue that is significant in circumstances where the linked article contains defamatory material. The recent decision of Justice Beach Jones in Visscher and Maritime Union of Australia, heard in the New South Wales Supreme Court, provides a concise summary of the Australian approach to liability for defamation in relation to material that can be accessed from a website via a hyperlink. The case involved an online article, which itself was not defamatory, published by the Maritime Union of Australia, relating to the decision of Mr. Visscher, the master in command of an ocean tugboat, to anchor the boat in the face of a nearby cyclone. MUA's article not only raised various concerns surrounding Mr. Visscher's decision, but also contained a hyperlink to an earlier article that expanded on these concerns in a manner conveying defamatory imputations. Accordingly, it was necessary for the court to consider whether the inclusion of this hyperlink constituted publication of the preceding defamatory material. By publishing the MUA article with its hyperlink to the Cootamundra Herald article, the MUA clearly accepted responsibility for the continued publication of that article. Its actions amounted to, at the very least, an adoption or promotion of the content of that other article. The MUA article introduced the reader to the danger faced by the MUA crew. It provided details about their plight and then invited a viewing of the full story by having the reader click on a hyperlink. In context, it conveyed that the details published in the MUA article were part of a more complete version, which was to be found by clicking the hyperlink. His Honour was content to depart from the Canadian Supreme Court decision of Crooks and Newtown, in which the majority held that a hyperlink was merely a reference to the existence of other content, rather than further publication. This was due to, firstly, on the basis that the decision was, at least in part, influenced by the Canadian Charter of Rights, of which there is no Australian equivalent. Secondly, that it was difficult to accept that the hyperlink would need to repeat the defamatory material to amount to publication. Thirdly, that the court's reasoning was inconsistent with the principle in Visscher, namely that defamation can be imputed against a defendant who approved, adopted, promoted, or in some way ratified the content. What was critical was the fact that the hyperlink was prefaced by the words inviting the reader to read the full story, which, in the court's view, made clear that the hyperlinked material was being endorsed, adopted, and promoted by the defendant. The court held that an online article's hyperlink to another, defamatory article amounted to a publication, according to the Visscher test. As can be seen, the context in which hyperlinked articles are presented can be of as much importance as its actual content. Nonetheless, online publishers should take particular care in the language used to introduce the hyperlink in content posted on their websites, especially where the linked material contains either known or potentially defamatory imputations.